call the second case on this morning's docket, State of Kansas v. Chandler.
If it please the court, I'm Nancy Ogle here on behalf of Dana L. Chandler, and I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. In this appeal, Chandler has raised 4 issues, and one of them I don't feel the need to address at all. The parties are in agreement that based on this court's prior decisions, that Ms. Chandler is required to be resentenced because the district court imposed 2 hard 50s, and this court has said the procedure for imposing that sentence, those sentences, was incorrect. So I won't go into any detail on that. I think the parties are in agreement. As to the 4th issue, so much of that issue happens to be whether there was prosecutorial misconduct. It overlaps so much with other issues in the brief that unless you have questions, I won't be delving into that in any detail.
I do.
Counsel,
I have a question on that.
Before we proceed with that question, Justice Johnson, as we ask counsel on the first case, would you mind taking about 60 seconds to give our audience a factual basis for why we're here today?
Certainly. Dana Chandler has been convicted of 2 murders in the first degree that occurred in July of 2002. She was convicted of murdering her ex-husband and his girlfriend, fiance, Karen Hartness, and the ex-husband's name is Cisco. She was not arrested until July of 2011, 9 years later. So from Ms. Chandler's standpoint, of course, one of the questions, it's not exactly an issue raised in the brief, but what evidence had come to light close to the time she was arrested. Anyway, she was arrested and then convicted of these murders that took place here in Topeka. Do you need
I think that's sufficient background. Now, Justice Johnson, you had a question?
With regard to the prosecutorial misconduct, you specifically pointed to 3 issues or 3 instances that you claim was misconduct. What can we do with the fact if we read the whole argument and perceive that or discern that there may be other erroneous statements or improper statements? What can we do with that? Are we limited to the instances of misconduct that you have submitted?
I don't believe so. I believe the court sua sponte can, if they, within an issue raised, sees more than what I included in the brief, I believe the court can base its decision on anything it finds.
What do we do with the law that says an argument not made is deemed abandoned?
Well, the issue was raised. The the individual facts that the court might base its decision on within that issue, I believe can go beyond the issue, the facts, the specific 3 instances that I cited.
And would you have some authority to cite to us to support that conclusion?
I don't off the top of my head, I'm sorry.
Thank you.
Let me tell you the other problem. I'm jumping you ahead a little bit, but the other problem that I'm having is on your issue 3, the 6455 bad acts
Right.
evidence. Where in there have you pinpointed for us where in the record that the issue was preserved by an objection and ruled on, and so that we can move forward to analyze them? I'm having trouble seeing in your brief where those points are.
Well, I do know the trial counsel, filed a response, an objection to the state's motion to include some of that, the evidence that the state was seeking to add. The court, granted some of those to Ms. Chandler, but still allowed some that we are now continuing to object to. So there is the response filed to the state's motion, as well as, I believe, hearing where.
I'm trying to find the contemporaneous, on the points you lost on.
Right.
You still have to make a contemporaneous objection in trial when that evidence starts to come in, and that's where I'm having trouble matching up your issues with the obligation to show us that it was preserved. What do I do with that?
Well, if the court would allow, I could supplement, but I agree that there has to be a contemporaneous objection.
We've interrupted your presentation.
That's
Please
okay.
proceed.
I want to talk about what you're interested in.
Let me jump into where I think this is where you were headed, but let me give you a springboard, and then
Certainly.
you could move back if you don't like it. It seems pretty obvious to me that there was no protection from abuse order in this case, as the state said in closing arguments. Given that, take me through the analysis on reversibility. I'll give you outside the wide latitude just for purposes of the question, and now get me into reversibility. I'm
sorry, would you mind repeating your?
Yeah.
I understand the reversibility.
Well, I mean,
premise.
my premise is that it's pretty obvious to me that there was no protection from abuse order, as the state said there was during closing arguments.
Right.
So let's just say step 1's complete. It's outside the wide latitude because the state can't talk about things that don't exist. Take me through the reversibility analysis. Take me through how that's ill will, gross and flagrant, and then how it tips the balance that the defendant didn't get a fair trial, given that misconduct.
Right. Well, Ms. Chandler was, as I've discussed, and I'm sure you're aware of, was convicted on circumstantial evidence, which, can be used to reach a conviction. But in this particular case, where with the admission, the statement that there was a protection from abuse or stalking case when in fact there wasn't, every bit of evidence on such a circumstantial case would be a significant fact. As far as ill will, I think it's more of a cumulative rather than picking out the one thing, the protection from abuse or stalking order, but also the state's pursuing a theory that really was based on inference upon inference. So I would say it's more of a cumulative effect with the protection from stalking not existing and the rest of the whole theory of Ms. Chandler learned of Cisco and Harkness's engagement 2 days before the crimes occurred, when there's really no.
So, counsel, if I can just understand your inference on inference argument. So the first inference is that during the 5-minute phone call, she learned that he was engaged to be married. That's inference number one.
Right.
And then inference number two is that based on that knowledge, she decided to drive from Colorado to Kansas and murder these two people.
Correct.
That's the heart of your inference on inference argument.
Correct. That they'd been divorced for years. I mean, granted, she called Cisco many times. They had children together that he had custody of.
There was lots of other evidence that supported that she was still very much entangled and kind of obsessed with her ex-husband. That's other evidence, but the inference stacking is focused on this idea that there was an original inference to be drawn about what was discussed during the 5 minutes, on which there was no direct evidence.
Correct.
And then the inference stacked on that is that moved her to immediately act upon the information she gained in that phone call.
Right.
So it all went to motive.
Correct.
Okay. Obviously, cases can be based on proof of motive and opportunity alone. We have cases that are affirmed on that basis, I would say, fairly regularly. Some of them have additional evidence, but not all of them have additional actual physical evidence that ties the defendant to the crime. So how do we get to insufficiency?
Well, I mean, all that the state has offered is 3 different instances where witnesses said, in fact, that they thought Mike or Cisco had told Miss Chandler that they knew that Ms. Chandler knew that Cisco was getting married, but when pressed on cross-examination, they couldn't, then they were just like, well, I think that's the way it is. And with the motive being such a crux of this entire case of, that would move Ms. Chandler to drive from Denver to Topeka to commit these murders, that's a very significant assumption or to be making on a 5-minute phone call that nobody knows what was said. I have just a few seconds if you have some questions. Otherwise, I'll turn it over to the state.
Do we have any more questions? Thank you, counsel.
May I please court Jackie Spradling on behalf of the appellee. And Justice Johnson, may I address you first and ask you if there are other instances of prosecutorial misconduct that you believe should have been or could have been cited. I'd happily address anything that you wanted to. As a beginning, I will tell you that sentencing is not an issue in this case, and so we do understand that the hard 50 sentences need to be reversed. For this court's information, I was one of the trial lawyers below, and so would add that as well. As to the defendant.
Ms. Bradley?
Yes, sir.
Before you get started here, address something that Justice Miles raised. I was just going through your brief. I don't see where you made a preservation argument on the 6455 evidence.
For the no contemporaneous objection?
Right.
You're correct.
And the preservation of evidence is a prudential rule, is it not? It's not jurisdictional.
Yes, sir.
And so we've said if you fail to make an argument or raise an issue, that's deemed abandoned.
You're right.
So why wouldn't the preservation be deemed abandoned in this case with regard to the defendant's 6455 issue?
I'm not sure, Your Honor, whether the preservation is required to address or prohibit a contemporaneous objection argument. I don't know the answer to that. I will tell you that it's my understanding that the law is solid and long-standing on the requirement for a contemporaneous objection.
Well, I'll jump in with what I think is misconduct, and that's right off the bat. You were warned not to refer or to have anybody in the gallery stand up, and apparently this is something that has occurred at some other time with this particular judge and you, because there was some reference to, I know, you know what I'm talking about, and you said yes.
Yes, sir.
And then there was, I don't want you to do that in this case. I don't want references to folks here at all. And then during your closing argument, you do exactly what the trial court emphatically told you what not to do. And the only reason I mention that is because the extremes to which the trial court judge went to inform you not to do that, and you did it anyway. Why isn't that misconduct, and why isn't that something we should look at? And what is your answer to that?
I can give you the history to that if you'd like, Your Honor.
I don't want to hear history. You were warned not to do that, and you did it anyway.
And actually, let me disagree with you, please. In the case that Judge Parrish was talking to me about, there was a closing argument in a case, I think it was Dimmick, although I can't promise you that that's true. And at some point during my closing argument, I looked at the galley and I said something about the jury's verdict being important to everyone. And almost all of the people behind the stage stood up. That is not what happened in the Chandler case. There was no one who stood up in the Chandler case. I didn't request anyone to stand up in the Chandler case.
Any reference to, and you said, I'm getting a look from what I'm talking about, and you're referring to the defendant's sister, I believe.
Yes, Shirley Regal, that's right.
And you're referring to someone in the gallery, and the court told you not to do that.
And let me disagree with the analogy, if I could, please. I do not believe that saying that the defendant's sister who was mean-mugging the state is akin to asking half of the galley to stand up during closing argument. So I respectfully disagree that I did the same thing that the court asked me not to.
Let me jump on the point that I started with defense counsel on. You'll agree that there was no protection from abuse order.
I'll agree that there was no protection from abuse order. There was
even though you said there was.
Yes, sir.
And in this, I was reading the closing argument again last night, and when that comes up, it seems like you hit it hard, fast. Number one, you said something that wasn't true, that there was a protection from abuse order. Number two, you said that means that the judge agreed that the defendant was a danger, because that'd be the foundation for entering an order for protection from abuse. And number three, you said that the defendant ignored the order.
Yes, sir.
And none of that's true.
It is true.
How is it true if there was no protection from abuse order?
Because what I should have said, Your Honor, was that there was a protective order. A protective order, as this court knows, is an umbrella.
Entered at the beginning of the divorce proceeding against both parties and concerning, I think in her case, the residents. That's a whole lot different than a protection from abuse order, isn't it?
Yes, but there were 2 orders in this case, Your Honor.
Okay, well, what do I need to look at?
There was a protective order in October of 1998. That is different from the protective order that was originally given in 1997, which fits the definition that you described. However, after the divorce was over in September of 1998, the defendant had still not signed the divorce journal entry, and she had filed the day after the last hearing multiple motions to reopen the entire case. It was after this, in October of 1998, that Mike Sisko requested a protective order and a case manager.
And the district court didn't give that protective order that was requested in 1998.
I can tell you, if I'm limited to the record on appeal, I cannot point to it.
You entered into evidence the entire divorce file.
No, sir, I did not.
Or a ton of it anyway. I mean, we've
Yes,
got
sir.
a huge exhibit
Yes, sir.
that's the divorce file, and there's no order in it.
There is no order in it. You're exactly right. There's no 19...
So you can't say that there was an order entered because there's nowhere in evidence that an order was entered.
I believe that testimony that an order was entered is also direct evidence that allows
So that'd be the detective's statement.
Yes, sir.
But the detective took it back in cross-examination and said, oh, I really don't recall whether there was an order. You'll have to look in the file that's in evidence.
Yes, you're
And
right.
there's no order in evidence. So how do you stand up in front of a jury and tell them that a protection from abuse order was entered? And then say that that means that the judge validated the claim and that the defendant ignored it.
Because a protective order, protection from abuse, and also a protective order is signed off by a judge who must agree.
But there was no protective, I mean, all I can do is go by what you said.
Sure.
So what you said was there was a protection from abuse order, and that's not true.
That is not true. It was a protective order, not a protection from abuse. And the difference is the protective order was issued in the divorce proceeding. A protection from abuse order is an order that a person applies for and is granted outside of a divorce proceeding. However, they are both protective of one person against the other. They both require, by judicial order, one person to stay away from the other. And having been involved in pretrial meetings and preparation in this case, I can tell you that there was a protective order. I said protection from abuse when I should have said protective.
And this is
it
in
your claim
October.
is it your claim that in that statement you are within the wide latitude given to prosecutors? Because that's really our step.
Yes, sir. I can tell you without certain that there's no ill will in saying protection from abuse rather than protective order.
That's the second, but that gets us in the
Yes.
second step. I'm sorry. Go ahead.
No, are we talking about the October 98 request?
Yes, sir.
Well, I'm confused. A month before trial, the state filed a 6455 motion asking to enter this evidence. And it only referred to a request for an immediate restraining order in October 98. I'm curious why the state wouldn't have asked that the court consider the order if there was one in fact in place.
I don't want to mislead this court. There is no document that I found in State's Exhibit 969, which was the divorce file. There's no document in that file that is either a protection from abuse or a protective order. So if I indicated that there was a document, I don't want to mislead you. I do know, speaking with the victim's family members, that the order existed. And that was discovered by Detective Foley as the lead detective in this case.
Can
And
we
do you-
also agree that on the 5-minute phone call in July 5th, I don't see how you say that during that phone call, the victim told the defendant that they were getting engaged. We don't know anything about what happened in that phone call, do we?
Yes, sir, we do know exactly what happened during that phone call.
Okay, how do we know that?
Part of that evidence was admissible and part of that evidence was not. We know exactly what happened during that phone call because Mike told his brother Tim. And Mike told his brother Tim, I'm going to get married to Karen, and I'm afraid of what that news will do when I tell Dana, because I'm afraid of what she will do to me. Because of the obvious hearsay exceptions, and not all of that falling into it, all of that evidence was not presented to the jury. But I stand before you knowing that that phone call took place. And
How do you get to say stuff that's not in evidence, though?
I didn't say all of that. Rather,
What you said was, they talked for 5 minutes, and Mike told Dana that he was getting married.
Yes, sir. And if you look at the testimony of Tim Sisko,
Okay.
I disagree with my colleague's interpretation of the testimony. What she says is that Tim Sisko's testimony was that Mike, thought, are you kidding, I'm marrying Karen. I disagree with that. If you look at the statements just prior to that testimony, Tim Sisko said that Mike had told him that he had told Dana they were getting married. And the word thought comes with Mike's reaction.
And does any of that relate to how does that relate to the July 5th phone call?
That's the phone call I'm talking about, Your Honor. And in addition...
That's not about her showing up in the breezeway and him reacting to her saying, I want to move back in? I'm confused.
Yes.
I want to know exactly what the testimony of the brother was. What was the testimony of the brother? Did he say, Mike told me that during the phone call he told Dana that he was getting married?
No, yes. Mike's,
During the phone call, not at some point during the phone call.
Yes, Your Honor.
And that's in evidence, that's just not in your brain.
I hope it's not just in my brain. That's...
The reason I'm asking that is not to be
Okay.
disrespectful in any way.
Yes.
But a few moments ago, your answer in response to my colleague's question was, I knew it, therefore I could talk about it. And that's not an answer.
Yes, I understand.
The answer has to be, it's in evidence. You
Yes.
understand that, of course.
Yes, Your Honor.
Okay,
And
thank you.
I hope I'm not confusing the two. Let's say that I am, worst case scenario, and we look only at Tim Sisko's testimony. Let's look at it that way. Tim Sisko testified that Mike had told the defendant he was getting married to Karen.
When?
And I want to limit myself to make sure that I'm not confusing. If I limit myself only to that, then Justice Beyer is correct. That's
the breezeway conversation.
Yes, sir.
Okay. We're trying to get you into that
Back
phone
to
call.
the-
Because I don't care about the breezeway. That
Okay.
happened 6 weeks before the death, and that has its own relevance to this discussion.
Yes, sir. I can point the court to Shirley Regal and Mark Malik's testimony. I do not believe that they are exclusively to that 5-minute phone call. I guess I'm supplementing the prior answer by saying that both of them testified that the defendant knew Mike was getting married to Karen. That does not specifically say the 5-minute phone call.
That's the problem. That's the problem you're faced with, because that's the first inference that your opposing counsel is attempting to rely upon for her inference stacking argument. Your case basically was a motive and opportunity case. Would you agree with me on that?
And identity, yes, Your Honor.
Right, but you got to identity
Yes.
because you said the defendant had motive and opportunity.
Yes,
It
correct.
was entirely an identity case, and the way you got to identity was motive and opportunity.
You're right.
You had no physical evidence.
I had no physical evidence, but it's not an entirely circumstantial case.
Okay, what's your direct evidence in this case?
The defendant's statements in 2 telephone calls from the jail.
That the state had her hair to
Not-
compare with the hair that was found on the casing, right?
Yes, in part, but not only that the state had her DNA to compare to the hair that was found on a shell casing collected from the scene, but also the defendant's worry that we had her hair, her DNA, to
Right.
make that comparison.
Right, which could be interpreted at least 2 ways, which is that she's guilty and she's worried you're going to find her out, which was your interpretation.
Yes.
Or could be the state has my hair and they could fake it. It could be interpreted that way. So that's that evidence. The other thing is her phone call with her sister in which she expresses relief that a witness has died.
She has celebrated.
Because that witness is the only witness who can place her in Kansas during the relevant time period, correct?
Yes, Your Honor.
Okay, so you have those 2 phone calls. Those are circumstantial. That's not direct evidence. That's not an admission on her part.
It is not an admission.
Okay.
It is a statement against interest as I interpret those
As you
phone-
interpret it, but it's open to interpretation.
Yes,
We
Your
don't have a confession from the defendant.
No.
We don't have physical evidence. We don't have a direct evidence case. We have a circumstantial evidence case. It's all about the identity of the perpetrator.
Yes.
And the way that you're proving identity is those 2 phone calls, your interpretation of them, which are circumstantial evidence, and motive and opportunity. And you have buku evidence of motive, because you obviously have an ongoing fractured romantic relationship that's led the defendant to engage in behaviors that some would consider bizarre and obsessive.
Right.
Okay. And then your opportunity is she can't account for her whereabouts in a cogent way at the time of the murders.
Correct.
That's your case. And that's why this inference on inference matters.
Okay.
And the first inference is what happened in that phone call. So I'm asking you
Yes.
today, what's your evidence on what happened in the phone call?
The phone call and the timing of the murders immediately after that.
That's not about the content of it. That's
That's
just
not-
reasoning backward from what happened later. The
Yes.
content of the phone call, do you have any direct evidence or any kind of evidence that's stronger than what you've already talked about on what happened during the 5-minute phone call?
Not that I can promise you is in the record rather than just in my mind.
Okay, thank you.
If another phone call had been made a full year earlier, that would be a substantially different case for you to argue, would it not?
Yes, sir. And
So I guess to cut through this, what led you to think that it was that 5-minute phone call in which the defendant learned of this impending marriage, as opposed to something
anything
else?
else? Because that's what we were told from the beginning in the investigation and the preparation in this case, Your Honor.
But that's not evidence, is
Yes,
it?
but might I cite to something that is
Certainly.
evidence? Let's say that I'm wrong and that there was no discussion of impending marriage in the 5-minute phone call. We at a minimum have a month before this breezeway conversation where the defendant asked to get back together. And that's significant because there were 2 times when the defendant was off grid, if you will. Once was a month before the killing and the other was during the killing, during the time of the killing. And so you can surmise that a month before, 6 weeks before the killing, this conversation in the breezeway then necessarily led to what I would suggest to the court it was a dry run. There was evidence presented at the trial that a month before the murders, she did not use her phone, she did not use her computer, she did not have any credit card purchases, she was not seen by anybody. And she admitted a month before, she admitted to her friend Ann Carrington that a month before she had gone to Mike Sisko's home, he was gone. She crawled into his window and looked around. So let's say that in everything I'm wrong and I can't prove that 5-minute phone call. It would be the same effect, the same filing, the same trial with the month before her having that information.
So you would eliminate from that calculus the fact that they had this 5-minute phone call whatsoever?
I can't eliminate it, Your Honor, because I believe that that's what happened. But I'm giving this court the worst case scenario. Let's say that I'm wrong on everything.
And that is that there was no 5-minute phone call. It was just she decided a month earlier to have a dry run to see if she could, quote, get away with this, unquote.
Yes, sir.
Determined, yes, that works, and so a month later she comes back and performs these murders. Is
Yeah.
that your theory that you're
It is.
giving us today?
Yes, sir, it is.
For our questions, all right.
Can I ask about a couple of other statements made during closing argument?
I'm sorry I'm out of time, but I will certainly.
Can she answer my question?
Certainly.
please? Okay,
Okay.
great. I just want to ask about a couple particular things. There was a statement about, or there was some discussion of some evidence about how she did not ask a question at the time of her arrest about why she was being arrested.
Yes.
And then during closing, let me just make sure I'm correct about that. Hold on one second, counsel. Yeah, I think this is all during closing argument by
Okay.
you. you know why she never asked why she was under arrest, because she already knew. That was the statement. It was kind of suggesting she already knew because she did the crime, so she wasn't surprised to be arrested. Do you know at the time that she was not asking, had she been Mirandized?
No, Your Honor, she had not. It was a
Okay.
pre-Miranda silence.
That wasn't clear from the record, so I wanted to give you an opportunity to tell me that.
Okay.
The other thing I wanted to inquire about had to do with this statement from closing. What these 2 gas cans, this is a little, transcripts are not always perfect grammar, so
Sure.
we'll overlook
Well,
that.
I
But
probably messed it up.
what these 2 gas cans does match up with is it gives her enough fuel to get from Denver to Topeka to do the killing and get out of the state. That's the significance of the gas cans. Otherwise, her 27 mile per gallon can't be done. So there was evidence introduced of gas purchases, including the 2 gas cans full of gas, right?
Yes.
But wasn't the evidence that would have been insufficient to get her from Denver to Topeka and back to Loveland, rather than sufficient to get her into Kansas and back across the Colorado border?
Yes, that's the reason why the statement was made. The 2 gas cans and the gas that was in them got her to Kansas, to Topeka, and out of state.
Okay.
Directly
and
north.
your recollection of the evidence is that would have been enough to get her car those places.
Yes,
But that was north to Nebraska rather than all the way back to Colorado.
right.
Okay, thank you for explaining that too.
Didn't the trial court prohibit that
No.
argument that you couldn't argue that she exited through Nebraska because that was speculation?
I don't
Okay.
believe so, Your Honor.
All right. But the trial court did rule that, or denied the admission of all victim statements. Did it not?
All victim statements.
Victim statements saying they were inadmissible hearsay.
No, Your Honor. You're partly correct, however. The trial court ruled...
Well, I'm just relying on the state's brief that says the district court denied the admission of all victim statements, finding they were inadmissible hearsay. The court, however, did go through the 3-step analysis on whether identity would be a separate basis for the admission of evidence.
And as to the statements that were being addressed at that point in the brief, that's correct. However, the court did allow some statements under 455, finding that if there were statements made by the victims that were close in time to... You want to say something?
Yeah, where I'm going is that would raise the issue of whether you can have 6455 admissibility if it's hearsay.
Yes, sir. You're right.
Okay.
Could just a clarification. The theory on the gas cans giving her enough fuel to travel to Denver, to Topeka, and then north to get out of the state. I thought the state's theory was that she traveled back through on I-70 and stopped in Waukene
She stopped in Waukene on the way here.
on the way here.
Yes, sir.
Counsel, we've taken a lot of your time
Okay.
with our questions. Would you like 60 seconds to wrap up? Or do you think you've established your points?
No, thank you. I'm good.
All right, any more questions? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
Just in response to opposing counsel discussing the 2 phone calls between Dana Chandler and her sister, speaking about the fact that the state had collected her hair for a DNA sample. And I realize, since this is, you all seem to be aware that this is a circumstantial evidence case, that her hair did not match any of the DNA collected at the crime scene, including some hair that was ruled out as being either of the victims. Opposing counsel also discussed the fact that, at least in theory, that Ms. Chandler came to Topeka to do a dry run about a month before the crimes occurred. And she mentions that Mr. Cisco wasn't home when she arrived, and so Dana, the evidence is that Ms. Chandler crawled into his house. I just want to point out that the crimes occurred not at Mike Cisco's home, but at the home of Karen Hartness. And as to not asking why she's being arrested when she was arrested, I mean, if she's watched Law and Order enough times, she knows not to say anything. Plus, this whole matter had hung over her for 9 years before that arrest, and she'd been interviewed, and relatives have talked to her through that time, and so I don't know why that. I would argue that that is not any kind of admission of guilt or has any relevance to the conviction.
So that arrest that was being referenced was the arrest that led to her ultimate conviction, the later, after the case had gone cold. That's not the arrest that happened within a month or two of the murders on the child support stuff?
As
Do you
far
know?
as I know, I thought
Okay.
it was
All right.
my
Thank
writer.
you.
Okay, yes, we agree.
Okay.
And I would just ask that, obviously, to reverse and remand as to resentencing, and to reverse and remand either to be dismissed because of the inference stacking, or retrial based on proven fact rather than the inferences. If you don't have any questions.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take